Good day, Dr. Sanjita. Today, our group will be presenting on the evolution of anti-suit injunction, namely the ASI, and take a clear stance on whether it will make a comeback or not. My name is Daphne, Ling and Zheng, and I'll start off with the basics of ASIs. ASIs are interim orders that restrain a party from starting or continuing litigation in a foreign jurisdiction. They don't bind foreign courts per se, but they act as a tool to prevent unfair parallel proceedings in another jurisdiction. Now, here is an analogy. Imagine there are two sashimi chefs who entered into a contract to prepare sashimi. Both of these chefs have agreed that any dispute arising out of the contract will be heard and settled by the sashimi head chef, since he is the master at solving all sashimi problems. And not surprisingly, one day, both of these sashimi chefs had a disagreement. And not surprisingly too, one of the sashimi chefs went against their prior agreement and went to find the fish and chips head chef to settle their dispute instead, probably because he had a better solution. When the sashimi head chef heard about this, he was so furious. After all, it's a sashimi problem and not a fish and chips one. How can you equate both of these together? This is more so when he was chosen by both parties to settle the dispute. And being enraged, he issued an anti-fish and chips order and basically saying that, no, this is a sashimi problem and you cannot go to a fish and chips tribunal. This, in legal terms, is called the ASI. The history of ASI can be traced back to 15th century England, where the royal courts have used them to stay parallel proceedings in ecclesiastical courts and common law courts. And by the 19th century, the use of ASI has expanded to other British colonies. Now, I'll be showing two cases which shows how ASIs are supposed to theoretically function. The first case is British Airways and Laker Airways 1985. In this case, the court denied the grant of an ASI because both parties have actually agreed to both UK and US laws, and the court held that bringing a foreign action under US jurisdiction was not an unconscionable conduct. The second case is Midland Bank and Laker Airways 1986. Yes, this case also involves Laker Airways and it happened 1 year later. But in this case, the court granted an ASI to protect a matter which is purely English in nature, like all the parties are English, all the matters inside are English, from being taken to the US courts and being interfered by the US antitrust law. English judges like Lord Gulf and Lord Hobhouse has upheld the noble purpose of ASI, saying that it acts as a shield to prevent the abuse of process. There are three theoretical purposes of ASIs. First, it is to prevent vexation or oppression. However, this is a very fact-sensitive test, as seen in Turner and Groveit 2004 and Airbus Industry and Patel 1999. And second, it is to uphold jurisdiction clauses, and to do so, there must be a jurisdiction clause in favor of the UK to show strong connection. Third is public policy, and this can be a problem as sometimes public policy can override jurisdiction clauses, as seen in Rieger Key. However, in short, the noble purpose of the ASI is to balance fairness and efficiency.
Hi, my name is Mah Yue, and today I will talk about how ASI was going in the reality. First, for noble intentions to problematic practice. Anti-suit injunctions, ASI was created to stop unfair or repeated lawsuit in a foreign court, especially when the party has agreed on a specific forum. They order a party, not the foreign court, to stop the cases. But English courts started using ASI more widely, even in a case with a weak link to England. Instead of just protecting the party, ASI become a way to gain legal advantage. As CoL 2003 say, they turn from a shield into the sword, with the party racing in the English court to get ahead. This suit often came from distrust of foreign court, straying from ASI fair purpose. As a result, ASI faced growth criticism, especially from the CJEU. Second is the gap between theories and realities. ASI were made for rare and obvious cases, like in Social Nationals and Liquid, which to protect the English proceedings while respecting the foreign court. But English court has expanded their use, even in the case with a weak link to England. This change led to party to seek ASI early for a tactical advantage. ASI shift from a defensive tool to a way to block foreign suits or enforce arbitrations, especially under English law. Although this helped protect arbitrations, it strained the relation with the foreign court, which see ASI as an interference. The UK Supreme Court now supports this wider use, favoring the English jurisdictions and legal certainty. Still, Norton 2022 warned that this trend promotes the foreign shopping and weakens fairness, trust in the global dispute resolution. Still, Northern 2023 warns that this trend promotes the foreign shopping and weakens fairness and trust in the global dispute resolution. Third is abused by English court. Aggressors has increasing granted ASI even when the case has a little link to England. In Abbas and Patel, the House of Law refused an ASI as India was the correct forum. But in Simon Engineering and Bird's meaning, an ASI stopped a Texas suit through Brunei was the natural forum, showing that the court asserting more control. Cred in 2003 called ASI powerful but controversial for interfering with foreign court. Critics called this forum arrogant. And Turner and Grovit, Lord Hobhouse warned of unilateral interference, yet court continue using ASI. For example, in UD Credits and Rush-Chem Alliance, the Court of Appeal grant one even through arbitration was seated in Paris. These decisions may damage the international trust, turning ASI from fairness tools into instrument of control. Fourth is the CJEU pushback. The CJEU strongly opposed ASI under Brussels first regulations, seeing them as the threat to trust between EU courts. In Turner and Grovit, it's ruled that the English court could not stop the proceeding in Spain, since only the Spanish court is the first could decide the jurisdictions. ASI were found incompatible with the EU system. In West Tanker, even though the ASI aimed to protect the London arbitrations, the CJEU still disallowed it. It's held that ASI interference with other EU's court right to rule on jurisdictions, even and arbitration cases. Liba 2008 noted that English court used ASI to enforce jurisdictions or arbitration causes early on, but the EU approach gave that power to the foreign court. Also, Mara 2003 argued that this led to the Versace's lawsuits go ahead unchecked. Also, Daniel 2005 called ASI an affront to committees and a danger to international cooperation. In conclusions, ASI were means to protect agreed forum, but the English court always used them and causing the international tensions. In Turner and Grovit, the CJEU rules that ASI breached EU's rules and the Brussels first recast banned them in the EU's cases. Olangi 2024 questioned their relevance today, with the US and German courts pushing back. English courts are now starting to scare red, especially in the EU's matters. And that's all for my part now, thank you.
Hi, my name is Deborah, and today I'll be taking on the analysis segment of our group presentation, elaborating on why ASIs are a problem. Firstly, it's because ASIs are extraterritorial in nature. This means that when an English court grants out an ASI, they can directly intrude into the foreign court proceedings in an EU member state court, extract the matter and bring it back to their own courts to be settled with under the English jurisdiction. And I think this gives a pretty much a very domineering stance, as it goes against principles like judicial sovereignty and also the principles of mutual trust and respect, thus directly going against the spirit of the Brussels recast. However, I actually want to analyze the impact of ASIs on non-EU member state courts, because it almost reminds me of this colonization mindset where the British sort of felt like they were superior than Southeast Asians and decided to, colonize us because they felt we couldn't lead ourselves. So in relation back to ASIs, when foreign courts who are non-EU member state courts perceive the English courts granting ASIs and doing this, they will find them antagonistic and self-important, and thus I think it actually replaces global cooperation with control instead. The second issue is with regards to the lack of guidance in case law, because different cases say different things in terms of whether a judge should grant an ASI or not, resulting in what I would describe as a doctrinal maze. So let's go back to the starting point in the case of Airbus, which laid out committee as the foundation of ASIs. This essentially means the English court must have sufficient interest or connection with the matter in question. Now then we will have to dissect what committee means. And from cases, unfortunately, ranging from Hilton to some protects to SNIA, they all define committee differently. Committee has been defined ranging from practical convenience to the spirit of cooperation. However, in the case of Donahue and Amco, Lord Hobhouse attempted to narrow down the test by stating that there must be strong reasons before the granting of an ASI. However, I think this attempt is futile, because what are strong reasons anyway when you toss it in the hands of different judges who have no standard test to use in determining whether the reason is strong or not. And lastly, we have the Turner and Grovit case, which mentioned that there must be an existing proceeding. However, then again, why would you want to keep ASIs around with the problems that I have just described? Therefore, our group now proposes that ASI should be dealt away with. mainly because ASIs inject uncertainty, and as an instrument, the only thing it should be doing is bringing certainty in uncertainty. So why should we keep what confuses us? We deserve better. Then also, ASIs do not achieve the goals of the Brussels recast anyway. Objectives like the need to maintain certainty, promote mutual trust, and also promote the freedom of movement of decisions. But ASIs function in a way where they force a decision to move back to the English courts. So how can there be freedom if you use force? However, some people reason that ASIs are not the problem and that ASIs are just a symptom of an underlying illness, with that disease being the Brussels recast itself. And they argue this because the Brussels recast does not explicitly provide anything to prevent forum shopping. And this is stated by Requejo in his journal article. And many other academics also may think this way. And my counter argument to that is basically that ASIs may be a symptom. I agree to that. It's tucked in with the noble purpose like what Daphne has established just now. But it should not be deemed as a cure to the problem. Because if it's deemed as a cure, to me it's like when a patient takes a pill to address one health problem, but it arises in many cumulative side effects that are detrimental to the body. So that is how ASIs are to me. Even though they may solve one problem, there are so many side effects to that I've already tried to establish during my analysis part. So what my opinion is that ASIs should be stopped entirely, and that if it's continued, it will only deepen the systemic fragmentation that they were meant to remedy.
Hello, I'm Bethan, and I'll be talking about the demise of ASIs. In the past, courts were more inclined to hand out ASIs here and there like party favors. However, it is evident that there has been a growing reluctance to issue ASIs. It is no longer among the army of an aggrieved party seeking to restrain proceedings anywhere in the EU. Now, as for the effects of this demise, let's first look at the aspect of arbitration. Since the possibility to issue ASIs is no longer available, contracting parties may increasingly choose their seat of arbitration outside the EU. Here, the ECJ decided that issues such as the applicability and validity of an arbitration agreement would be subject to the general principle under BR, that the court first sees of the matter should be allowed to determine jurisdiction. Others say that the main problem the foreign court is dealing with is still the actual disagreement between the parties, not just the arbitration agreement. Because of this, ASIs try to stop these court cases, interfering with how BR works. Second, there is a greater focus on BR, especially under Article 31 sub 2. Now it emphasizes the role of the court first sees to determine jurisdiction, potentially leading to a focus on procedural efficiency rather than relying on blunt tools like ASIs. Now, will ASI make a comeback? Well, it can be argued in theory that ASI may possibly come back under the veil of Article 31 sub 2, which serves a similar function. Here, it allows the court second sees, which has the JA, to instruct the court first sees to stay their action. But what happens when the court first sees refuses to do so? The use of ASI here could be justified, with the reasoning behind it not being an attempt to protect the JA, but rather to uphold 31 sub 2. Here, we can also consider post-Brexit. When the UK was part of the EU, it had to follow the BR framework and decisions from the CJEU, which banned ASIs against other EU courts. But now that the UK has left the EU, English courts are no longer bound by those rules. This means that they can grant ASIs again, even against EU states, especially to stop cases from being brought in EU courts when there is an exclusive English jurisdiction clause. Brexit has created legal uncertainty, and businesses might try to take advantage by going to courts outside of what they agreed. So ASIs may be increasingly used to fight back and protect those agreements. However, in practice, ASI is unlikely to come back within EU law, and in our opinion, it shouldn't. The courts have made this position clear, ruling the principle of ASI effectively blocked. And referring back to our argument earlier, although Article 31 sub 2 sort of performs a similar function as an ASI, it serves merely as an alternative solution that reduces the actual need for ASIs. Reintroducing ASIs would be a case of 2 steps forward, 1 step back in the overall development of EU law. They are just blunt, coercive, and pressuring, creating unnecessary jurisdictional tension. It should be buried within the past. ASIs had their moment, but EU law has simply outgrown them.